Dear professors, dear students, esteemed Professor Szilágyi, thank you for your invitation and the opportunity for me to speak about this very interesting conference. The paper of Mr. Juhart tackles a very interesting issue from the perspective of a person that works at a constitutional court. So in the field of constitutional law and justice. It is the problem of enshrining new constitutional basic rights and liberties in the Constitution, namely the right to safe drinking water and sanitation. It is well known that a Constitution establishes the fundamental principles of state organization and functioning, and that is why it has two dimensions. Dimensions that concern the establishment of the organs of the state, and the second dimension is the one of attributing the competencies to these bodies. But beside that, modern constitutions comprise a catalogue of fundamental rights and liberties. Or, if they do not have such a part, they have acts of constitutional nature that establish such a catalogue. Of course, this catalogue can be changed. The legislators, the constituent legislator, the delegate legislator can add new rights and liberties, but it cannot affect or eliminate those rights and liberties that have already been enacted. We are speaking about the so-called eternity clauses provided by the national constitutions that preclude the possibility to affect the existent rights and liberties. But what is the constitutional basis to add or to supplement this catalogue? The answer is human dignity. Human dignity is the source and basis of all the rights and liberties. The human being is not an object, but a subject of the law. As you can see on my PowerPoint presentation, I put some case law of the German Constitutional Court that considers human dignity as a fundamental right. The French Conseil Constitutionnel that considers human dignity a principle of constitutional value. The ECJ considers it as a general principle of law, and I've put a decision from the case law of the Romanian Constitutional Court, a supreme value of the state, and it has double nature, a general principle and a fundamental right in the same time. So legislators, especially the constituent ones, tries to identify the rights that originate from human dignity. It is an impossible mission to have an exhaustive catalog, and that is why we can notice that specific right appears as the society develops or appears new challenges or needs. But our society is a textualist society. You cannot have only human dignity in your constitution. That's why you have to enshrine basic rights, fundamental rights. And enshrining them in your constitution is a guarantee that they will be observed. We know that in the experience of Hungarian Constitutional Court that we have a so-called invisible constitution. So human dignity can suppose a lot of rights and liberties. But it is, as I've told you, a guarantee to have them enshrined expressly, expressis verbis, in the constitutions. You know, the composition of the courts can change, and all the time the rights are in a continuous movement. The right to safe water. Such a right may seem new, but actually it is not. The societies and the legal world didn't recognize it, maybe, or the societies were not aware by its own independent existence of this right. Also, it has a long existence as part of other fundamental rights, like the right of life or decent living conditions. I can give you an example. You know, every constitution has the right to a fair trial enshrined. But some constitutions have the right to defend yourself. And you can ask, why to put the right to defend as an autonomous, as an independent right in your constitution? Because of historical reasons. And I go back to the Romanian constitution, and I have in Article 21 the right to a fair trials, and immediately I have the right to defend yourself. You can say it is enough, the first right, but no. The constituent legislator can develop this right and can put guarantees in the constitution. But it's an instrumental importance in some parts of the world that this right to become an independent one, even if it being in connection, of course, with life, with human dignity, with the right to health. But when a right become independent, when a right become autonomous, I cannot give an answer, but I can tell you that there may be a historical background, a social, economical, or political background that makes a right to be to have an own existence in a constitution. The right we are talking about, it's it's an absolute or a relative right. Because it's close connection and link with the right of life, it is an absolute right, but its effectiveness is subject to state regulation. I see two main components, a procedural and a substantive one. So, the substantive one is absolute in nature. It cannot be denied, and no other action can affect it, because it's a general truth that quality water sustains life, being a sine qua non condition for the existence of it, of the life. I can mention that it is protected even through criminal means, so by the criminal code. And I can give you an example in Romania, a decision in which you have these developers who built block of flats, and it happened near Bucharest that a person built such a block of flats, and he connected the pipeline of the sewage water to the main fresh water pipeline. Of course, this is a criminal offense. But the person came to the Constitutional Court saying that, okay, but it didn't happen anything. Nobody has died. Nobody was injured. But the Constitutional Court said, regardless of this, it is a criminal offense that takes into consideration the jeopardize the human life and the quality of the water. So the threat, not the result. So the procedural part, I think, it is the most problematic of this right. And it is the subject of constitutional and legal limitations, regulations. As Mr. Juhárt said, there can be identified a series of obstacles in assuring the substantive part of the right. Legal uncertainty, represented by the bylaws, and this is the system in Romania too. We have a lot of bylaws from the local communities regarding the procedural aspect of this law, of this right. Another obstacle: how to connect to the public water network. Economical value on the one hand, and on the other hand, you have the basic right. And I can mention a hilarious situation in the case law of the Constitutional Court. You know, a block of flats, condominiums, they have only one principal pipeline that connects to the main pipeline of fresh water. A person wanted to connect his flat directly to the main pipeline. Imagine if 50 or 100 flats want to connect individually in the main public pipeline. It is almost impossible. And the court expressed that, yes, you have access to water, but you cannot have it individually with your pipeline. The third obstacle was the suspension of drinking water supply due to non-payment. I will try to be short here. I will present a case opposite to Mr. Juhárt. Actually, you think that the ombudsman has to protect the vulnerable persons. But I have here a decision of the Constitutional Court in which the ombudsman contested a law that provided the obligation of the supplier, it doesn't matter, electricity, water, heat, in case of non-payment of debts that are contested to the courts, to continue to supply the respective customer until a final judgment will be delivered. The ombudsman considered that such a measure affects the right of the supplier to property and economic activity. The court performed a proportionality test between the two competing interest rights, the interest of the supplier and the interest of the customer, and maintained the presumption of constitutionality of that provision, giving precedence so to the interest of the customer. The court noted that such a measure has a legitimate aim, as it assures the basic needs of the human being, mentioning the need of water. The law is meant to satisfy such needs. That assures the subsistence of human being. Such an aim is legitimate. But unfortunately, the ombudsman didn't tackle the problem of vulnerable groups. So the ombudsman was defending the supplier, not the customer. So maybe that would have been a better issue to be raised and solved by the Constitutional Court. So the problem of vulnerable persons, not the problem of the interest of the, the interest, so a general public interest, instead to put this question to defend the interest of the supplier. However, I noticed that sometimes the procedural part of this right is a condition to exercise other rights, to obtain a building permit. In Slovenia, but in Romania, no. So you can build a house to have building permit, but without having this permit for connecting to the freshwater pipeline. Conclusions. I said that I will be short. So I think that this right is an expression of the Rio Declaration of Sustainable Development in the environmental dimension. You know, a declaration has no legal effect. It is soft law. And enacting a fundamental rights, it has normative content, normative effect, and it is a legal instrument to fulfill the scope of the Rio Declaration. So actually, it is a right to the offered to the citizens, and not only state obligations. It is much powerful that such a right to be part of the general catalogue of rights and liberties. Thank you very much.